court does call the case of the people of the state of Michigan versus Matthew Wheeler.
Good afternoon, Your Honor. Laura Billenberg, on behalf of the people.
Good afternoon, Judge. Larry Margolis on behalf of the defendant, Mr. Wheeler. Please state your name.
Good afternoon, Judge. My name is Matthew John Wheeler.
All right, this is your motion, Mr. Margolis.
Thank you, Judge. Where would you like me to stand, Your Honor?
Wherever you'd like, sir.
I don't know why I like the podium, but let's try that. Judge, we are seeking to have the bond reduced in this matter. It's set at $150,000 cash or surety. It's not something that Mr. Wheeler is able to make. He is a 44-year-old resident of Washtenaw County, has lived his whole life. I say that initially because in the bond, I have the arraignment where his lawyer at the time said he has no family in the area, and the magistrate said that he may be a flight risk. I wanted just to correct the record on that because his family, the entire family except for his brother, lives in the state of Michigan, lives in the directly in the Metro Detroit area. His father is in the courtroom today. His brother, who came in from Maryland, is in the courtroom today as well. Mr. Wheeler was taken into custody in this case on October 15th, and he's stayed in custody since that time. As I said, he has very, very strong ties to this community, and he is not a risk of flight whatsoever. He has no reported criminal history, Your Honor. He has a long and positive employment history. He's been employed as a martial arts instructor, and that's where the allegations arose from. But he's been employed there since 2010 when he was an instructor, and then he took ownership of the school in 2022. So for 15, give or take, years, he's been teaching at that location. This is the first allegation that arose. He's been working with kids throughout that time. He has a lot of positive support. I've attached some letters of reference for Your Honor, and I can go through those, but I obviously don't need to. I've been getting more emails to my office. What can I do to help this individual? I was walking into court this afternoon. Attorney Jonathan Sachs said, "Larry, come here." He brings me over. He says, Mr. Wheeler has been coaching or teaching my son for years. Do you need me to stay around? And I said, yes, as long as you can. But then he had to go. He said, please use my name to the court. This man has standing in this community is what I'm trying to tell the court. He's very close to his family. He's a caring son and brother. He's highly disciplined and respectful of others. His mother would be here. He cares for his mother in large part. She is aging and not well. She wanted to be here, but she's at Chelsea Hospital right now. So she is sending her support from afar. As far as him being a danger to the community, Judge, he's not. Again, he's lived in this community his whole life. This is his first criminal charge lifetime. He's actively involved with his defense. He would do nothing to jeopardize it. And we're seeking to have Your Honor reduce this to either a 10% in a lower amount that the family can make. There are conditions that can be placed upon him. So we're asking Your Honor to modify that bond. Defer to the people at this time.
Response.
Your Honor, I wrote in my motion that I am asking that bond remain as set. I reviewed and charged this case and originally requested a $50,000 bond, and Magistrate Odetella, of his own volition, set the bond at $150,000 because he thought that was appropriate. The victim in this case, the assaults and the grooming started when she was 12. She started training in martial arts when she was 6. Defendant was someone that she very much trusted and admired and looked up to, and the allegations are that he took advantage of that and of a child, began grooming her and assaulting her when she was 12, and then 3 days after the most recent incident, she reported it and told her mom what was happening, what had been happening. He touched her breasts, her thighs, her vagina, and this was when they were alone together, either in his vehicle or at the martial arts studio. Also made, several concerning statements to her, like that the age gap isn't that bad. I have concerns given that, like, yes, these are the first allegations, but his job is essentially direct access to children. I have concerns, obviously, given the report of this child, and I think that the bond is appropriately set at this time, especially given that the magistrate saw it, that it was even more serious than I requested, and increased it to $150,000 on his own. So I'm going to request that bond remain as it is set.
Briefly. Judge, Mr. Wheeler denies any of the sexual allegations that this young person is making. He has been working with children and adults for 15 years. He had been working with this individual for 8.5 years, and in her own statement, she says that there was some touching that happened, and then she continued to stay for the next 20 months. There's a lot of facts.
Yeah, but I mean, I don't know what you're asking me to make out of that, Mr. Margolis.
Only that there's one person who's alleging this, and that one person continued to stay at the dojo.
Yeah, but this isn't a circumstance. Well, it's a child that then she doesn't remove her. She's not in a position to remove herself, right?
Well, I mean, she rose up and became a coach, and she was very involved. That's all I'm saying.
No, what I'm saying is that you're making it sound as though this is an individual who this is going on, or is at least alleging that this is going on, and chose to stay. I mean, she's a child, so the reality is she's going to be there until such time as she is afforded to tell her parents, because they're the ones that are going to take her out, right? I mean, or are you saying something different?
No, I'm not gonna quabble, or is that the word? I don't think it's important to contest that point with the court. How's that?
Yeah, but I'm trying to figure out what your statement, how I'm supposed to take your statement that this is occurring to her and that she stayed. What am I supposed to do with that notion that she stayed? Because if she stays, it's my presumption, unless you know something different, is that she stays because she can't or doesn't tell her parents, so then she's not taken out.
I didn't get that impression from my review of her statement and the discovery, Judge. I got the impression that she stayed because she said it was her whole life. The dojo and the dojo community was her whole life, I think, is what I recall the statement being that I reviewed this afternoon.
Okay.
The point is that I'm trying to make is that there's a PPO in place. Once she stopped going, there was no problems with Mr. Wheeler, trying to get her to come back or going to the house or anything like that. He's a respectful person. He's a good person, Judge, and he denies this. And so all I'm asking is for his presumption of innocence to be, upheld, allow him to get the benefit of the doubt without, there's no evidence other than her statement, which is common in these cases, as Your Honor well knows. Again, he's been in this community, contributing to this community. That's why I attached, for Your Honor, all the reports, the Quest references. Quest has changed my life. An amazing experience. Our kids love spending time at Quest. So we have a community of children that have had great experiences. And yes, we've had this one that is now making these allegations. but it's probable cause. He's never been in trouble in his life. He's college educated. His family's here in support. He has a close family. I'm just asking for him to be given a reasonable bond such that we can work together on the outside.
What would he, presuming he were released, is he going to continue to operate this business or what?
So he doesn't have to, if the court were to release him, there are conditions. He should not, if there are court such as like, okay, let's not allow him to be around kids unsupervised. That's an easy one. There's been no, I mean, this.
Well, but that's not an easy one because, I mean,
as a condition.
As I read, because I pulled the swear to and the other thing, and then as I'm reading this, I mean, there's an indication that somehow or another he's up this child. Why is that occurring? I mean, I get
no, it's a great question.
Teacher.
Yep. So the family only had one car. He was close with mom and the family too. So the family would rely on him for transportation for a long period of time. This was a family that had been at the dojo, and these are small, tight-knit communities. And so this was a family that was at the dojo for 8.5 years. And so they had one car. And so mom would request that he assist in the transportation. And he would. That's why, to answer the court's question.
So the other part of that, though, is that, so if I were to release him or he were released, he would go back into the same environment to work?
Not necessarily. I think the lease has now been gone. He has other abilities. He also has another job doing something else. I forget exactly what it was. What was the other job? Yeah, he also was working at a warehouse doing shipping and receiving to make extra money. Yes, that was his business, and he eventually in his life.
Hey, I'm not getting a straight answer. If he were released, would he go back to operating this business?
No.
But it's an ongoing concern, right?
Again, I have to look at the man's history. I have to look at his family support. I look at his ties to the community.
Mr. Margolis, I get all that. What I'm trying to figure out is the allegations. I have to balance the protection of the public and the safety of the public, as well as this defendant's risk of flight and other factors. And so I'm asking these questions about what is he going to do? One thing that I would be certainly is always the case with these types of cases is access to children. And so I asked the question, is he going to operate this business? And I'm not getting a straight answer.
The answer is no. The answer is no.
But so what happens to this business?
It no longer is going to be operating, Judge. The lease, I believe he's already had a problem with that.
With what?
I think they either terminated his lease or he's out. Quest no longer operating. Is that correct? Correct. It's not even operating anymore.
When did that stop?
Probably when he got arrested.
May I just briefly respond to?
Yeah, I just want clarification. The business stopped when he got arrested. So he didn't it's not something else that stopped the business. This stopped the business.
That's correct.
So it continued through October?
When did,
When,
August.
August? Well,
Oh, the business.
yeah, that was in October, Judge. This was reported in August.
I know, I get that part, but I'm just saying. I'm trying to figure this out. If he had told me I closed the business last year because of for X reasons, how do I know that this business has ceased?
So these allegations blindsided him. And the arrest obviously was shocking. And so the business is just pretty much bolted.
Okay.
And again, much to the dismay of a lot of parents who sent me letters saying he's been working with my kids for years. We have great respect for him.
Okay, fine, but that doesn't. This really doesn't answer the question about the business stopping, because basically there's still a business. It's just not running because he's here with us. I mean, that's probably a more appropriate way to look at it, isn't it?
Yes, sir.
So, is his lease terminated? I mean, I would find it hard to believe that a lease doing the business, I find it hard to believe that if this occurs in October, that a lease terminates to that extent.
His brother has been working with the lessor. What do you got? Yep. Yeah, he's been in touch with the property manager. He's asked for some grace because they don't know what was going to happen. But my client indicates that he has no intent to go back and operate that business.
Well, see, now that's a whole different scenario, because what you were telling me is that the business isn't operating, that the lease had been terminated, and that the business isn't there. The reality, as I'm hearing it now, is the business is there. It is, for all practical purposes, it is a functioning and ongoing concern that may not be doing anything at this very time.
I totally agree with that, because he is the business. Without him there, it can't operate. But because of the court's concern, we don't need to be in that business or operating that business.
Yeah, but Mr. Margulis, you can't tell me that his lease hasn't been terminated.
That was my fault. I thought that it was terminated, Judge. I must have, thought that when a conversation with my client. That's not something that he is saying either. So that's me. I don't know what respectfully that has to do with his bond.
Well, it has everything to do with his bond, Mr. Margolis, because that's the concern that the court has. He has access, just on the allegations, he has access to this child through that business. You're asking me to let him out where there are other children. And so naturally, I would want to know, is this business going to continue? That's what it has to do with his bond. And in fact, I have great concerns and can't see that of whether or not I should release this defendant.
I understand, Judge. I guess I was looking at it a little bit differently. When she reported this, she stopped going. And I know you're concerned about other potential allegations coming out, but I wasn't looking at it that way because I'm only hearing the positives from parents saying, we loved his work with the kids, with my kids, reaching out as a parent of two of the younger students, R&M, tremendous respect. So, he has a lot of goodwill with other people in this community who have children. In a perfect world, he'd be able to continue, and the complainant in this case would be not going back because she's not. But we are willing. I mean, he understands the court's concern, and that's why he is willing to not operate the business. The lease is not terminated, but there can easily be a condition that he can't go to that business. Yeah.
Miss Willie.
Thank you. I think I just have 3 points. Mr. Margolis sent as part of his motion, and also I reviewed, and he stated on the record, that he has a lot of community support of people saying, they send their kids, but do these people know why he's not there? Is my question. Second, when viewing the website of Quest Martial Arts, there's still an option to sign up now for spaces in November. So it still seems to be operating, still seems to be allowing people to sign up. Third, I take issue with the suggestion that we're placing blame on the child for continuing to return and spend time with the defendant as if that is her fault. She was a huge part of this community, very clearly. She started there when she was 6 years old. And so what it took for her to tell someone what happened to her was probably very challenging because she had the understanding that, this was going to end for her. This community that she had was no longer going to be available to her because she couldn't be around him anymore and she couldn't deal with this anymore. I think she blew up her own life too and doesn't have that community anymore. So I take a lot of issue with that. It's somehow a child's fault for returning to a trusted figure when he was grooming and abusing her. I think given all of this information, I just think bond is appropriate. And I would ask you to rule it that way.
Anything else, Mr. Mills? Because I'm still, I'll be honest with you, I don't like the fact that I didn't get a straight answer about this business. Because this business is in a lot of ways, when you just analyze it on its face, the epicenter of this. Because without this business, there isn't access to this child and potentially access to other children. So one of the concerns that the court is going to have is the protection and safety of the public. And if that, and one thing that the court would have to take very seriously is cutting as best it could, if I were to release the defendant, is cutting that access. And I'm not getting a straight answer about this business. I'm not, you're telling me initially that it ceased because the landlord said this, then it just was,
I get that,
excuse
Judge.
my French, it was just a very squirrely answer to what this is and whether or not it exists. And I'm not even sure, at least at this point, I probably haven't gotten to that point yet, but if he were released, how would I fashion any language that he can't do this. Because apparently it's still going, the business is still going. I mean, there still is the option for students to take classes in November. Hey,
That's on me. I didn't look into that with him. I just was making assumptions, Your Honor. There are easy ways. A home confinement is one way. Don't go to Quest is another way. Again, there's a PPO in place. She is not gone for many months. I'm sorry about not understanding that we still have the website up, but that's easily taken down, Judge. He denies these allegations. He still is presumed innocent. He has no criminal history.
I'm not taking away his presumption,
Understood.
Mr. Margolis. I am just looking at, I mean, let's be real about it. Typically, when you have these types of circumstances, regrettably, and I'm not saying that's the case here, but regrettably, it's usually not just one. There, you all of a sudden get others that come out. And so, from the best I can understand, this is a business that's operating. And in a lot of ways, based upon the information that you supplied to the court, there are these children that are involved with this business and taking classes there and that kind of thing. And so naturally, one of my first questions are going to be is there still this place where these children are going to congregate and be part of this? And I don't get a straight answer. I don't. And the only conclusion that I can come to right now is this is still an ongoing concern. And then the question is how do I keep him out of that? How do I keep him from doing, if I were to release him, how do I keep him from doing all of that?
They're all canceled.
They're all what?
The business is not, he is the business. There's no other Quest without him. Yes, we haven't been booted out of the place yet, Your Honor, but everything is canceled.
Not terminated.
The lease is not yet terminated. That's correct. That was me making assumptions that I should not have made.
The business as a business concern is still operational.
It is not. It is not. And I know that's not the answer that, and you're shaking your head, but again,
I'm shaking my head because I'm trying to figure out how you get to that. Is the business in existence?
yes, it still is in existence. Yes, but it's not operational and all the classes are canceled. That's all I'm saying.
And how do I know all of the classes are canceled?
That's the proffer we're making. You can put him under oath and ask him if you like.
Well, if he's not telling his attorney and correcting his attorney, why do I think he's going to tell me the truth?
I don't think I asked specifically the questions that Your Honor would like me to ask.
Yeah, but Mr. Buckles, if you're saying something and it's not true, he can stop you at any moment and say, no, that's not it. And how do I know they're canceled? What was the process by which all of these things have been canceled?
His brother's in the courtroom. Mr. Wheeler had his brother send a message to everybody canceling all classes. Because he's been in here, he has not been able to shut down the website. That is what I'm being advised.
Do I have a copy of that email? Has that been provided to the people?
His brother can be questioned as well. He's in the courtroom. Is that correct, sir?
If that is correct, innocence and stop, prosecution stop.
Pardon?
Stand up, please, if you know.
I've been working with,
Why don't you come up here and introduce yourself to the court? What's your name, sir?
My name is Adam Wheeler. I've been working with Matt to the degree possible while he's incarcerated to at least do some triaging to the business, understanding that operations cannot continue if Matt is incarcerated. So I've worked with former leadership to issue a notice to current enrolled students that classes have been canceled until further notice. My father, who's in the courtroom, has helped me to put signs on the doors to say that class is closed till further notice. And I also worked with the former leadership to put a stop payment on all tuition.
So, was there an email sent to all students regarding that?
Yes,
Is there a copy of the email?
I can provide it to Larry as soon as I get out of here.
Give me right now.
I don't have my phone on me.
Oh.
I didn't think that was allowed.
How many students are there?
Between 40 to 50. Does that include adults as well? That includes adults as well.
Have the parents been notified as to why he's not there?
I can speak to that to a degree. In the email that notified the currently enrolled students or parents of the closure, the former leadership, a member of former leadership, and I included our contact information for questions and concerns. So I have spoken openly with some of them, and I'm happy to confirm more of that.
Well, what was said in the email?
That due to unforeseen, I believe, I'm paraphrasing, due to unforeseen circumstances, classes at Quest are closed until further notice. It was very short, and then there was a second email to notify them of the stop payments to the tuition, and then the inclusion of my contact information to reach out with any concerns.
Papers too.
Not yet, but a reporter has reached out.
Mm-hmm.
But if I'm a parent and I'm sending my child there, then all I know at this moment is that things have stopped. But I'm not informed as to why. Is that what I'm hearing?
To a large degree, there has not been a communication to the entirety of the enrolled students or parents. As I said, some parents have reached out or I've reached out for character letters, and that has warranted transparent conversations as to why the closure is happening.
And there was that letter, sorry to cut you off, sir. There was the letter from that one person that I had sent on. It was the last one that I had sent. I think it was either a couple of days ago where someone said he's aware of these and he can't speak. He was very circumspect with what he was saying. I can only talk about his relationship with my family, and it's been amazing. I'm being clear that I don't know everything about everything, but I think it's a small community. I would surmise that, you know, a lot of folks are aware of this. I do know that the complaint.
Okay. Certainly one can make all kinds of assumptions, but I don't know why weren't the parents told?
I mean, that may be a better question for the other side of the aisle here. I do know in her statement.
What do you mean? Why would that be their question?
Well, I mean, surely Your Honor is not upset with me for not issuing a.
I'm not upset with anybody. I'm just asking a question.
Yeah. I think some of them were. I know that the complainant and her mother, at least the complainant, the minor, talked with her dojo brother and let him know. I know that she talked with another, according to her statement, she talked to somebody else at the dojo and let him know. So I'd be hard pressed to believe that a lot don't already know, given the closeness of this organization.
Okay. So I go back to my point. You're sending an email out. Why aren't the parents informed?
That he's been charged with these offenses.
Yeah, I mean, he can say that he hasn't been convicted of anything. He can deny absolutely he can say, but they can say whatever they want to say. I'm just trying to figure out
Yeah.
why haven't they been informed
Yeah.
that this is occurring?
If Your Honor wants to make that a condition of bond,
I'm not.
Yeah. It's
I want to know
embarrassing.
why. So you're asking me, Mr. Margolis, to let this individual out under circumstances where it's almost a higher level of trust and the authority involved is at a higher level in this type of environment. In a martial arts environment, whether you're sensing, but you've got a higher level, and you're asking me to release this individual back into a circumstance that it potentially could occur. And I'm trying to figure out, well, when this happens, what's been done with this business? Do these parents know? I mean, these other individuals.
Yeah, I'd venture to say some do and some may not. But they've probably been asking a lot of questions why they can't go anymore and why cancel. I think for my people, for my guy, it was such a shock. This is like a very unusual situation in his life. He didn't know what to do. The brother, I can't fault the brother for not letting everybody know. But maybe that's something that we can do.
Look, I'm not faulting anybody. I'm trying to, in setting bonds, I'm trying to make a risk assessment. That's really what I'm trying to do. And part of the only way that you can make a risk assessment is to look after this. I imagine it was a shock as to what has transpired then. That's one way of going about doing it. I worry about a setting that, and I don't really want to call it a school, but a trusted setting where this allegation has been made, at least to the extent of reasonable suspicion and probable cause, charges have been brought, and this this thing doesn't do anything to inform everybody else that may or may not be at risk. I don't know. I mean, one can say, yeah, well, we let certain people know and we did this, and I guess that's one way of looking at it. But I mean, there would also be, and I'm not sure which way one would head, there could be a darker reason in looking at it that will let some people know, but those that may come out and say something else, we won't let them know. So we target our information. And I'm not saying that's what was done. I'm just saying there's a lot of ways one can look at this. And where would the defendant, if the defendant were to be released, where would he be residing?
Manchester. Sorry. But his mother has a home in Tecumseh.
Does the defendant have a different address than he did before? Because I saw something on So
That was his former address, Your Honor, Lake Village Drive, apartment 201.
I know. But then my understanding was there was going to be another place. And now I'm being told that he would be residing with his mother.
So he has a new girlfriend, and his intent during all this, he was planning on moving in with his girlfriend. That's off the table now, not necessarily because of the girlfriend, but because I think she has children, and we don't want to pressure any, we don't want to make the court or magistrate, we don't want to make the magistrate concerned about that. His family is here, they're loving and supportive. Mom, he's lived there before, probably, and mom has a house that is suitable.
Tell me, if he's out, what stops him from operating this business?
He has other opportunities for employment.
What stops this business from operating?
He's closed it down. He's not, or he.
It's not closed down. That's the problem. The problem is, I asked the question, what stops him from operating the business? There is nothing. In fact, there is nothing that stops contact to the individuals that haven't been contacted to say to come back to the.
He'll close it down, Judge. It has to be closed down. That's what stops him.
I'll be honest with you, I don't want to be, well, I'm in the position of sometimes having to second guess things, but I am troubled by the responses that I'm getting to my question, particularly as it regards this business, which by its nature attracts young people. And when I ask about that business, when I ask what this, but I'm not getting for the court's perspective, a satisfactory answer that that's done.
Well, please don't hold that against my client. That's me.
Well, I'm not holding,
Well, I mean, I understand.
holding it against anybody. I'm saying I'm not getting a satisfactory answer. It is what it is. This business is not closed down. It still exists. It's still there.
But he won't go there. I mean, that's easy enough to fashion as a condition. That's why I keep going back to that point. He won't go there.
Then why are people still encouraged on the website to sign up? I mean,
It's an oversight, Judge. This took the whole family by shock. They're freaking out. They don't know what to do. I should have thought of this and told them, this is what we need to do. This is what we need to do. I frankly, I didn't think about that. I didn't think about that. That was what was going to be most concerning to the court. But it's easy enough to fashion a restriction
well,
for
Mr.
on
McDonald, I
house
don't know how
arrest.
you can't not think that for any court, and I'm sure it was a factor for the magistrate, and usually is, which is why he can't go to that other address. It's anything that could put him in contact with kids. That is basic and simple to anything set in terms of setting a bond on these cases. It is that basic.
And I believe that was part of the magistrate's order, is that he can't go to that address. I believe, but it's Easy enough to put that as a condition. Again, these are allegations. While they're serious, this court and I have seen more serious type. These are there's no penetration alleged here. Not to lighten the
Mr. Margolis, I don't think you even want to say that.
correct.
That's a 12-year-old, 14-year-old girl who has alleged to have, I don't even know how that came out of your mouth.
I'm sorry.
I'm put this court recalls the case of the people say Michigan versus Matthew Wheeler,
We're willing to be the people.
Larry Margolis on behalf of Mr. Wheeler.
and he's here. Anything else from either side for the court rules?
Nothing additional from the people here.
Briefly, Judge, he is Quest. Quest is no longer going to be operating. He has a lot of support in the community. This is a good man who has done a lot for the community. He is denying the allegations. He has a place in Tecumseh to stay if he were to be released. We're asking for a reasonable bond that the family can make.
Given all of the circumstances in the case, and the court's primary concerns are whether or not the defendant is a risk of flight and a danger to the community. In these cases, danger to community can sometimes be viewed as a very tricky thing, but a lot of it has to do with the access to children, which was the focus of the court's questions. As I made it clear as the argument was going forth, I wasn't satisfied with some of the answers, some of the actions that have been taken since the point of the defendant's arrest and incarceration and arraignment on these charges, which almost lead the court to believe that this concern will continue. I do not know, but there is continued this access to enrollment. I understand what the brother is indicating that they've done, but I also I hear what was said and then what turns out not to be the case. And so at this juncture, based upon what I'm hearing, the motion to reduce bond or modify bond will be denied. Bond will continue. In saying that, if circumstances change that can alleviate some of the court's concerns, I have no problem entertaining a motion again. But in terms of what I'm hearing at this point, I'm going to continue as bond and deny the request. All right. This is also set for PCC at this time. So what are we going to do with that?
I think we have all the discovery in. Is that correct?
As far as I am aware, yes.
Detective, do you anticipate anything additional?
Not at this time.
Okay. We can, since he's in custody, Judge, I'd ask it to be set for an exam date.
How soon do you want it?
What's the next available?
Well, we're kind of jammed up there, but the 25th.
Is that Thanksgiving week?
That is the week of Thanksgiving.
Yeah,
Tuesday.
I'm going to be out of town. The week after that or the week before would be my preference.
Either is fine with people.
And Your Honor, I heard Your Honor's ruling loud and clear, and we anticipate addressing that immediately.
So which date do you guys want?
I mean, if we can set it for the 18th and then that's too busy for you.
Well, I'm not going to set it on the 18th. I mean, if I mean, I will set it for the 18th if that's what you want me to do, but I don't know how many witnesses you anticipate having.
I mean, the 18th is fine. It just needs to we need a date certain because the victim's obviously gonna have to miss school.
She what?
She's gonna have to miss school, so I just don't want her to comment for.
Is it Ann Arbor Public Schools, do you know, or at least
Community.
Washington Intermediate School District, because I can go with that. Okay, hang on. Just do that. I can give us, but so the problem's going to be that means that if I try to accommodate that, you're not available, that I'm going to get closer to the break time for school, or I will give a special time later in a day to conduct it. So it'll be a sooner date, but later in the day, so that.
I mean, the 18th is fine.
That's fine.
Okay.
Okay, understanding that she would then, I mean, I'm going to set it at 9, and that's going to be a whole day.
Yep.
Is that what you want to do, folks?
Yes.
All right, well, thanks. And then, because then one of these will clear. Got it. Okay. So here's what I'll do. I'm just trying to meet both needs. You want it as soon as possible, obviously. You got a victim that there's a school issue. So I will set the 18th, but I'm going to set it later in the afternoon. And that way I can accomplish both, I think, in that regard. Okay.
Thank you, Judge.
So I'll set preliminary examination in person on November 18th, 2025 I'm going to set it at 2 because I want to make sure we have enough time, because I think people in the evening have childcare issues that they have to deal with. So I want to make sure that there's not a problem there. So I'm going to set it at 2 p.m. on the 18th. I would like to say that I'll be in this courtroom, but I may not. It may be that I'll have to shift around to a courtroom, and that'll be before me.
Okay.
Get it in and get it heard. Okay.